A special thank you to each of our subscribers who make this channel possible. Here's today's story. In a significant ruling on Tuesday, the Supreme Court has paved the way for the Trump administration to enforce a controversial ban on transgender individuals serving in the military. The decision comes after an appeal from President Trump's legal team, which sought to lift previous injunctions imposed by lower courts that had blocked the policy. The justices issued a brief order without providing detailed reasoning, a common practice for emergency applications. The ruling has sparked widespread condemnation from LGBTQ+ advocates and allies, who view it as a discriminatory measure that undermines the rights and dignity of transgender service members. The dissenting opinion from the court's three liberal justices, Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson, underscored the gravity of the situation as they argued against the appeal. This ruling is consistent with the court's historical deference to military policy, but it raises serious questions about the implications for thousands of active duty troops who have served honorably. The policy, introduced by Defense Secretary Pete Hegseth, states that individuals with a diagnosis or history of gender dysphoria are deemed incompatible with military service. Estimates suggest that there may be over 15,000 transgender individuals currently serving in the U.S. Armed Forces, with the Defense Department indicating that approximately 4,240 active duty members could be affected by this new directive. Advocates for transgender rights have labeled this move a purge of dedicated military personnel, emphasizing that it contradicts the principles of equality and fairness. Lambda Legal and the Human Rights Campaign Foundation expressed their dismay, highlighting that the ruling represents a devastating blow to transgender service members who have proven their commitment to the nation's defense. They criticized the administration's assertion that the policy is not a ban, pointing out that it effectively targets those who have undergone gender transition. Upon taking office, President Trump expressed concerns about what he termed radical gender ideology within the armed forces, asserting that maintaining high standards of troop readiness and cohesion necessitated the exclusion of individuals with gender dysphoria. In a lawsuit filed by 7 transgender service members in Seattle, the plaintiffs argued that the president's decree was rooted in prejudice and disregarded their demonstrated capabilities. One of the lead plaintiffs, Commander Emily Schilling, who has served as a Navy pilot for nearly 2 decades, transitioned within the military under a policy established by the Biden administration. U.S. District Judge Benjamin Settle ruled against the new policy, stating that it was discriminatory and based on outdated concerns that had been addressed when transgender troops were allowed to serve openly. He noted that Schilling, with her extensive flight experience and accolades, should not be discharged solely based on her transgender identity. Judge Settle's ruling imposed a nationwide injunction against the policy, but the Supreme Court's latest order allows the Department of Defense to begin enforcing the ban while legal challenges continue in lower courts. The implications of this ruling extend beyond the individual service members affected. It raises broader questions about the military's commitment to inclusivity and the rights of all individuals to serve their country. As the legal battles unfold, advocates for transgender rights and military personnel alike will be watching closely, hoping for a reversal of this policy that many view as a step backward in the fight for equality. That's all for this story. We upload videos every day covering many different subjects, so hit that subscribe button to stay informed. Thanks for watching.